Hello, and welcome back to Coin Lady channel. You might be surprised to learn that the world of crypto is involved in a lawsuit. That matters more than the SEC's case against the Ripple exchange. Blasphemy. Yes, you heard me. Well, that's the opinion of attorney Deaton. That's why you see that headline from Crypto Basic right now. Deaton elaborates on why the case against Custodian Bank is more pressing than those against Ripple and Coinbase. Perhaps he is correct. He makes a fair point. I'm not entirely convinced. I need some more time to mull it through. When it comes to the current SEC assault on crypto, I tend to concur with attorney Deaton's viewpoints. I'm still open to arguments. I'm not sure if I've reached that point yet, but I could be pushed. The problem is that there are simply too many variables at play right now. I mean, look, if you're talking about, and I don't think this would happen, so like, say we get a disastrous outcome at the district court level and then it makes it all the way up to the Supreme Court and we still have a disastrous outcome, then that's just like, a disaster. I have no idea. That's hardly the worst case scenario, but to help attorney John Deaton make his case, I'm going to give you the whole picture. However, I'm not sure. Perhaps he is correct. Who knows? After you listen to what he has to say, please share your thoughts with me in the comments area. However, I'd like to clarify something first. I come from no financial or legal background. Neither legal nor financial counsel is being provided by me. Nothing I say or write should be used as a basis for making financial decisions. I'm just a fan who occasionally posts videos to YouTube discussing random crypto-related things for kicks. That's okay. This is a continuation of a narrative I worked on a few months ago. U.S. Federal Reserve rejects request from custodial banks for direct oversight, as reported by Cointelegraph on February 23. In other words, a custodial bank is a cryptocurrency bank. They are staunch supporters of cryptography. And the ultimate goal was to guarantee all customer deposits at 100%. As you may or may not know, the United States uses a fractional reserve banking system, wherein banks keep no more than a negligible fraction of their customers' deposits in reserve in case of a financial emergency. This requirement was relaxed during the 1918 influenza pandemic. It was about 10% back in the day. Perhaps I'm mistaken. Although my recollection may be off, I believe it to be the correct figure. From what I can tell, at that point, they flipped it to a 0% rate. Assuming public trust in financial institutions, this should not be an issue. However, the situation could quickly escalate into a death spiral if too many people try to withdraw funds at once and are unable to do so. That's the main worry, then. Having the money on hand would allow you to avoid that. Wow, that's a fresh idea. That's why Custodian Bank proposes doing it. They wanted more than 100% in reserves, and settled for 108%. Even though there is no reserve requirement, at least, that's what I've been led to believe, many banks, or perhaps just the smaller ones, I'm going from memory here, keep just about 8% of their deposits in reserve. That's why they're all like, okay, so we'll have the full 100% plus an extra 8%. There you have it. That's obviously where we got that figure. Unfortunately, I can see why the Fed isn't thrilled about this. They like the system they've built and the authority they enjoy exercising over it. And now there's a bank where depositors can rest assured that their money is safe and secure at all times. If that's the case, why would you ever consider switching banks? Right. The issue is clear now, right? Look at the headline, because something has happened, which is why John Deaton said what he did. Cointelegraph published the news only yesterday. U.S. Supreme Court denies Federal Reserve's request to throw out Custodian Bank case. A federal judge in Wyoming dismissed the Federal Reserve and the Federal Reserve Bank of Kansas City's petitions to dismiss, marking a victory for Custodian Bank in its legal battle against the federal. In June 2022, the digital asset bank filed a lawsuit against the Federal Reserve, saying that the Fed had unreasonably delayed approving their master account application from 2020. The bank was formed by Caitlin Long, a former executive at Morgan Stanley and an early advocate of Bitcoin, to serve as a conduit between the cryptocurrency industry and the US dollar. The Federal Reserve's last attempt to have Custodian Bank's case dismissed was again shot down. The Federal Reserve's effort to give itself a veto over state bank chartering decisions will finally be tested in federal court, and for that we are grateful. According to spokesperson Nathan Miller, Studio Bank stated in an official statement to Cointelegraph, "Someone who works as a cleaner. In October of 2020, we applied for a master account at the Federal Reserve. If approved, the bank would then be allowed to access the Federal Reserve's financial infrastructure. Over 196 million transactions were handled by Fedwire last year." The bank's presence in the cryptocurrency area was cited as one of the reasons the Federal Reserve Board declined the application for membership in January 2023. Yes, you are correct in saying that. Use the devil if you work in cryptography. The government has come to this conclusion. We're simply a bunch of nasty idiots, right? Okay, so maybe you're a crypto degenerate. As far as I can tell, that's the front-facing message. I intend to effectively destroy crypto by bombing it to the moon. Which brings us to the tale of John Deaton saying, "Hey, there's actually a case here, and that's this one more important than the Ripple and Coinbase lawsuits." John Deaton tweeted, "Big win," in reference to the section of the story I mentioned. Congrats. Congrats. More specifically, Caitlin Long yesterday, the Federal Reserve's move to dismiss was denied. Custodian Bank's arguments seem reasonable, thus it can proceed with its case. Legally, we prevail. That's right, it's something we've noticed repeatedly. And then there came Attorney Deaton's tweet. "Perhaps the most significant instance in existence right now," he remarked. Some were taken aback by what he said next. So, he elaborated on his previous comments by stating the following. "In spite of the outstanding lawsuits involving Ripple and Coinbase, I have seen some individuals express astonishment that I would rank the Custodia case so highly. All of these factors are crucial, yet few people know about Caitlin Long's incarceration or the others. Today's crypto businesses require financial services, whether we like it or not. The SVB Signature Bank just experienced choke point 2.0. Also, etc. Take a peek at the latest from Binance US. How can we restrict crypto-deny banking ties, or perhaps completely shut them down? I won't be reading this, but I'll take a screenshot of it anyhow." Full screen sharing from Deaton. If you'd like to take a moment to read this, I'll pause right here. A message from Binance US. That's exactly what we did. In addition, I wrote about it. As of Wednesday, June 13th, Binance informs us the fiat on and off ramp will be closed. Even if they've stopped allowing cash withdrawals, you may still deposit and withdraw crypto. You should be concerned about Binance. But no more, at least for the time being, will purchases or withdrawals be made in US dollars. So, to be clear, I am aware of the fact that it is the bottleneck. It's only when you ask, and because Deaton has more to add, I'll allow him. But you know, when I think about this reality, like I would say, I would surely concede the point quickly and readily that if all on and off ramps were eliminated, that would be tremendously harmful. Bad news for cryptography. It would be tragic if that meant no more children could be adopted. So, you've convinced me. However, I'm still open to arguments about which legal action is more pressing. Though I'd appreciate it if some of you shared your thoughts and tried to steer me in a certain direction, I see no hope of that happening given the current state of affairs. So, you know, even if Custodial loses this case, I don't think all entrance and exit ramps would disappear. I feel like they're being attacked here. However, I find it hard to believe that that is the deciding factor. Like I said at the beginning of the video, the SEC versus Ripple case might have far-reaching consequences if it were to make its way to the Supreme Court and the court ultimately ruled in favor of the SEC, classifying the token as a security. I think that would be a terrible outcome under the circumstances. I mean, come on. then perhaps that would indicate that this other case is more pressing. I'm not trying to convince you of anything, I'm simply letting you in on my current line of thinking. I have only just begun to think about this today. There is no right option, so I'll consider your feedback and maybe take a hint in one direction or another. Therefore, it doesn't matter what you believe. It's not completely out there to believe either way, you know. However, Deaton's legal counsel added that Custodian Bank will not practice fractional banking while still keeping 100 in reserves. With full reserves, you won't have to worry about being unable to withdraw your money or other assets in the event of a bank run. However, the Federal Reserve does not approve of this groundbreaking idea. In this case, the judge recently dismissed the Federal Reserve's petition to dismiss, clearing the way for a charter custodian to proceed with discovery after the Fed arbitrarily declined the bank's application to be a custodian. This is one place where I agree wholeheartedly with Attorney Deaton. He didn't put it quite this way, but I think this is his general point. I don't want to put words in his mouth, but it would be the same as if there were no on or off ramps and the rest of it really doesn't matter. Accordingly, I'll concede that point. What I'm having trouble with is just what I mentioned a few minutes ago. If Custodian loses, is that the end of this? You could, I suppose, make the same case for Ripple. Is this the final chapter? Even if the Supreme Court were to rule against it, that would still set a significant precedent. That could be an even worse outcome. So, which of these two scenarios is more crucial? I incline toward saying Ripple, but perhaps there is another point of view I haven't taken into account. Perhaps Lawyer Deaton, if you could help me understand his reasoning better, I might even be convinced by him. However, please share your opinions with me. I figured I'd bring it up because it's a good discussion starter, but now I'll shut up. No, I don't give out financial advice. Nothing I say or write should influence any transactions you make. Please like if you enjoyed it and subscribe my channel. See you later, bye.